about what is myth and what is truth in family law.
Hello, everyone. I'm attorney Farah Kamal, owner and founder of Kamal Law Firm, and I'm here with my associate attorney, Kitty Crutcher, and we wanted to do a continuation of our Friday talk with you. So when we do our consultations, we always have people that say and ask these questions, which are generally myths and they're not truth. So let me start off with the number one most common one that we get. Our clients think that moms always and automatically get custody.
That is the biggest myth you're going to find in family law. Your gender doesn't determine who gets custody. What determines who gets custody is what is in the best interest of your children, what is offering them the best stability, education, and do the things that are necessary. So moms don't always get custody in the state of Texas.
Another really common one that I get is usually whether it's husband or wife, whoever stayed home, they often feel that if they've stayed home and never worked, that they're not going to be entitled to anything from the property division.
That's not true. In Texas, the courts generally look at a 50-50. There are some cases where we can do what's called a disproportionate share of the property, but it's normally a 50-50. Anything purchased during your marriage has the presumption of being community property unless it meets some criteria that takes it into separate property. But that's an analysis we can do if you call for a consultation.
Another common one that we get is people think that if the spouse that's ordered to pay child support is not current or is in arrears, that you can withhold your child and not allow them to have time with them simply because they haven't received any child support.
That's not true. Withholding a child in denial of their court-ordered visitation can land you in jail in the state of Texas. They are two separate parts of an order and they stand on their own. You cannot deny custody or visitation just because you're not getting child support.
Another common one that we get asked is people often think that if they don't have any assets, properties, or bank accounts in their own name, that they're not going to be entitled to anything from the division of property at the divorce.
Again, that's not true. State of Texas is 50-50. Your presumption is if it's purchased during the marriage, it's community property regardless of whose name it's in.
So you see, guys, this is exactly why you should set up a consultation and have your situation evaluated, because it's very common to misunderstand how the law really works in Texas. So give Kamal Law Firm a call and our team member will be happy to set you up.